So, yes, you were under arrest. There's a warrant for your arrest. And the officers are going to get with you on this.
This is one of those hearings where the tone flips instantly from routine docket to "you're not walking out today." The judge isn't just reading charges. The judge is stacking consequences, one brick at a time. Aggravated assault with a deadly weapon, prior robbery convictions, a controlled substance conviction, and then the words that change everything: habitual felon status. That's not courtroom drama. That's a sentencing range that can swallow decades of someone's life. And what makes this moment even more intense is that the defendant is being told he's under arrest in real time, because a warrant has popped up and the bond situation is suddenly in question. Watch closely how the judge explains it. This isn't just up to 20 years anymore. If the enhancement allegations are true, the floor becomes 25 years and the ceiling becomes 99 years or life. That is the kind of warning a judge gives when they want the record crystal clear. You understand what you're facing, you understand why you're being detained, and you understand why bond is about to change. The question now is simple. Does this person belong back on the street right now, or behind bars until the case is resolved?
25 CL 1228. Are you, you're Inland Faulk? All right, Mr. Faulk, you were charged here in 25 CR 1228 with the second-degree felony of aggravated assault with a deadly weapon. Do you understand? Which carries with it up to 20 years in prison. Because this was handed up back in September by the grand jury. And this goes on to allege, though, that you were convicted of robbery 2 times in the 252nd District Court on the same day, May 24th, 2002, long ago. After those 2 convictions were final, it is alleged in the indictment that you committed the offense of illegal possession of a controlled substance, a 3rd-degree felony, and you were subsequently convicted of that on February 21st, 2019, also in the 257. So if all of this is true, you are looking at habitual felon status, no less than 25 years, no more than 99 years confinement in prison or life in prison is what you're facing. You understand? That's what the guy was facing yesterday in yesterday's trial, who got 55 years in prison.
This is the legal heart of the shock. Enhancements. The judge isn't finding him guilty right now, but the indictment is alleging prior convictions that, if proven, trigger habitual offender punishment. That's why the judge is spelling it out so bluntly. 2 robbery convictions from 2002, then a 3rd-degree controlled substance conviction in 2019, and now an aggravated assault allegation involving a deadly weapon, described here as a vehicle. Under habitual statutes, prior felonies can dramatically raise the minimum sentence. So when the judge says no less than 25, that means even the lowest possible prison exposure becomes a generational chunk of time. And then comes the immediate consequence. You are under arrest. There's a warrant. That's the court shifting from explanation to action. This isn't optional. This isn't negotiation. A warrant plus a new indictment can wipe out the comfort of an old bond situation, because the court has to make sure the defendant actually appears and the community is protected while the case moves forward.
You are under arrest at this moment. Do you understand? Yes, you are under arrest. There's a warrant for your arrest. And the officers are going to get with you on this, and they will be able to talk to you about it. But this has popped up, and you got an answer for it. We're gonna make a copy for you so you can have a copy of it. But your bond is revoked due to this warrant. And what was his bond before? What was your bond on this?
I think it was 20,000.
20,000 for habitual felon? and committing aggravated assault.
Judge, I believe the issue here is the case was filed and dismissed, and I believe he bonded out on that first filing. And when it was dismissed, there was no warrant, and he didn't bond out on the new indictment. So I believe that's what's happening today.
That's correct. He has no bond on this new indictment. So he's just a make bond.
So,
I don't find this bond enough at $25,000 anyway. Who said the bond? Bad. But you are a habitual felon, sir, and these are two prior violent crime convictions and then a serious illegal possession of a controlled substance. And now this is aggravated assault by threatening to use a deadly weapon, namely a vehicle. So your bond is increased to $100,000. There's a way to avoid all of this, is to not to commit crimes. And if you post a bond, you will be at home confinement. You must have a GPS device. You
This
cannot.
is the legal heart of the shock. Enhancements. The judge isn't finding him guilty right now, but the indictment is alleging prior convictions that, if proven, trigger habitual offender punishment. That's why the judge is spelling it out so bluntly. 2 robbery convictions from 2002, then a third-degree controlled substance conviction in 2019, and now an aggravated assault allegation involving a deadly weapon, described here as a vehicle. Under habitual statutes, prior felonies can dramatically raise the minimum sentence. So when the judge says no less than 25, that means even the lowest possible prison exposure becomes a generational chunk of time. And then comes the immediate consequence. You are under arrest. There's a warrant. That's the court shifting from explanation to action. This isn't optional. This isn't negotiation. A warrant plus a new indictment can wipe out the comfort of an old bond situation, because the court has to make sure the defendant actually appears and the community is protected while the case moves forward.
GPS device. You cannot leave the home except to and from work, most direct route possible, to and from hospital care, to and from acquisition of food. And those are the other purposes. And that's the way it is. Do you have an attorney?
also,
Are you unable to hire somebody? Fill out an indigent form and an attorney will be appointed to represent you. We'll appoint somebody today from the public defender. You're taken into custody. That's the rulings of the court.
Say something.
No, sir.
My boys, man, real quick, my boys in the back.
Sir, your bond is too low. Sir, you are a danger to the community. Your bond is far too low under the circumstances that we have. Plus, there's a warrant for your arrest. And it's not a debate, sir. Follow the rules of the court. Thank you.
We'll just get him to fill out an indigent form for the jail.
Next is Jaquan Lazard. Next is...
As to the assault battery, how do you plead?
Your Honor, I'm sorry to interrupt the court. It was brought to my attention that I had put a little bit of a different offer in writing to Mr. Carter. I don't know if I did that inadvertently, but I will honor that. And that would mean that would change it to him pleading to still the added count of an attempt R&O with dismissal of the balance of charges.
Well, he didn't know that. You didn't know that?
He
I'm
did.
asking him. You can't tell me what he knows. I'm talking to him. You didn't know that?
Yeah, I did.
So why you ain't say that? And when I said if that's your understanding of the offer, why you say, Judge, that's not what they told me?
No.
You don't think you got to protect yourself out here?
Yeah.
You got to do better. You got to get a belt and you got to protect yourself.
Okay.
You understand that?
Yeah.
Okay, so we're dismissing the assault and battery?
That is correct, Your Honor. I apologize.
No worries. As to the attempted resisting obstructed officer, how do you plead?
Yes.
And that's because you believe you're guilty of that?
Yes.
Are you sure?
Yeah.
Factual basis.
Mr. Robinson, on or about December 15th of 2025, were you in the city of Lansing?
Yeah.
Ingham County?
Yeah.
More specifically, 3933 Phoenix Drive?
Yeah.
And at that time, did you come in contact with police officers as they were investigating a call that they received?
Yes, ma'am. Yes.
And at that time, were you in a altercation with a Mr. Johnson?
Yes.
And the officers gave you commands to stop and you did not immediately stop?
Yes.
And they actually ended up having to say that command more than one time, isn't that correct?
Yes.
And you refused to do it at first, correct?
Yes.
I have nothing further.
People are satisfied.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. This matter is scheduled for sentencing March 6th at 9 o'clock in the morning, okay? We're gonna go downstairs and check in with probation before you leave here today, and they'll get you scheduled for a pre-sentence interview. You have any questions at this time?
No.
Any additional matters for the Director Johnson?
No, Your Honor, thank you.
Thank you.
Here's what's happening in plain English. The defense is saying he bonded out on an earlier filing that was dismissed, and when the new indictment came down, he never posted bond on this case, which is why today suddenly becomes an arrest event. That distinction matters because bond follows the active case, not the old one that got dismissed. So when the court realizes there's effectively no proper bond covering the current indictment, the judge treats the prior amount as meaningless. And the judge's reasoning for the increase is laid out clearly. Prior violent convictions, a serious drug conviction, and a new aggravated assault allegation. The judge calls him a danger and raises bond to $100,000, then adds strict conditions if he does bond out. GPS monitoring and essentially home confinement with limited travel only for work, medical care, and food. The most direct route language is classic court control. This is the court trying to reduce risk while still allowing release, but only under heavy supervision. Would you call that fair or too lenient given the alleged history?